Hi everyone, thank you for bearing with us for your patience as we get all the tech sorted. So welcome to our Human Rights in Practice event, Families and National Security. Welcome both to all of you who joined us in the room and to those watching on live stream as well. Before introducing our very esteemed panel for today, I'd like to start off by thanking all of our many co-sponsors for the event today. First, the event is organized by the Center for International Comparative Law and the International Human Rights Clinic. And we also have a very robust list of co-sponsors today, including, I know many of you represent these student groups. So co-sponsors are the Coalition Against Gendered Violence, the Duke Human Rights Center at the Franklin Humanities Institute, the Duke Human Rights Center at the Keenan Institute for Ethics, the Duke Law Center for Law, Ethics, and National Security, the Human Rights Law Society, the International Law Society, the Muslim Law Students Association, the National Security Law Society, and the Women Law Students Association. So thank you again to all of you for co-sponsoring. And turning to our three speakers, I will introduce them in the order in which they will be speaking. So we will start off with Professor Fatima Ahdash, lecturer in law, Goldsmiths at the University of London. We'll then be joined by Professor Fionnuala Ní Aoláin, the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. She's also University Regents Professor at the University of Minnesota and holder of the Robina Chair in Law, Public Policy and Society, as well as Faculty Director of the Human Rights Center at the University of Minnesota Law School. And finally, she's a Professor of Law at the Queen's University of Belfast School of Law in Northern Ireland. And Professor Jayne Huckerby, Clinical Professor of Law and Director of the Duke International Human Rights Clinic. So each speaker will speak for just under 10 minutes, and then we'll open it up for Q&A and wrap up just around 1:15 to ensure that everyone has the chance to grab lunch before heading out. So thank you again to all of you for being here. I'll turn it over to Professor Ahdash.
Hi, I just wanted to double check and make sure that you can hear me fine.
We can.
Can, lovely, thank you. And I'll just share my screen as well, just so that you can see. Just a minute. I'm woefully inadequate when it comes to technology, so just bear with me.
It looks good.
Okay, is this all fine?
It looks beautiful.
Lovely, thank you so much. So good afternoon, everyone. My name is Fatima Ahdash, and I'm a lecturer in law at the University of Goldsmiths, London. And I'd just like to say a big thank you for having me here today with you. My research focuses on the interaction between family law and counter-terrorism, and the use of the family courts within the context of national security here in the UK. So I'm especially pleased to be participating in this seminar on families and national security, and I hope to be sharing with you some of the insights and points that I've developed out of my own PhD research, as well as my published research as well. So now, when we think of terrorism, we tend to think of it as a particularly public phenomenon. Terrorist acts are very spectacular acts of political violence that often take place in the public arena. And when the state responds, it tends to respond through its public laws and policies. So either through the criminal law, for example, by creating more and more terrorism offences, or increasingly, the state uses administrative measures such as control orders to deal with terrorism suspects. Now, it's not that these measures haven't had an impact on the private sphere of the home and the family lives of those that have been targeted by them. So if we take the case of control orders in particular, we see that counter-terrorism measures have always impacted family and family life, particularly in the UK. So for those who don't know, control orders were introduced in 2005, and then they were replaced in 2011 with the Terrorism Prevention and Investigation Measures, they're called TPIMS. And they allow the Home Secretary to essentially impose certain restrictions on terrorism suspects who can't be prosecuted in the open criminal trial for one reason or another. And these restrictions include things like long curfews at home, electronic tagging at home, restrictions on who can visit the family home, restrictions on the use of computers and electronic devices at home, sudden unannounced visits by officials, relocation orders, and so forth. So control orders and their successors, the TPIMS, essentially brought counter-terrorism to the home, significantly impacting the private and home life of not just the terrorist suspects who are subject to them, but also their families as well. But whilst these counter-terrorism measures might have had the consequence or the effect of impacting private and family life, over the last few years, especially here in the UK, the family and the home have come to be specifically and directly targeted, monitored and regulated in the name of preventing and countering terrorism. And this has mostly been done through the involvement of English family law in national security. So over the last few years, there's been a novel and growing body of cases coming from the family courts of England and Wales, referred to as the radicalisation cases, and these deal with the impact of terrorism, extremism and radicalisation on children and families. The radicalisation cases began to appear in the family courts around 2012, 2013, but they rose significantly in number in 2015 as a response to the wave of children and families trying to travel to ISIS-held territories in Syria and Iraq. And my data, retrieved through Freedom of Information requests to the Children and Family Courts Advisories and Support Service here in England and Wales, it shows that at the moment the number of these cases is over 350, although only around 45 are actually published and publicly available. And the radicalisation cases are kind of legally very diverse. So we have both public family law proceedings and private family law proceedings. So public law radicalisation cases involve the state, through its local authorities, seeking to remove children from the home or otherwise intervening in a compulsory manner in the private and family life based on allegations that a parent, or sometimes an older sibling, has been involved in terrorism or extremism. Private law radicalisation cases are different. So they involve allegations within the context of custody or contact disputes between divorced or separated parents that the other parent has been involved in terrorism or extremism. So in these private family law cases or private radicalisation cases, it's not the state that's accusing a parent of being involved in terrorism and extremism. It's one parent accusing the other of being an extremist as part of their overall separation weaponry. And what this shows really, I think, is the banality of national security, how it affects everyday life and family dynamics, reflecting just how deeply the language and concepts of counterterrorism have infiltrated our collective consciousness, to the extent that extremism has kind of become a cultural signifier of bad parenting, if you like. So the radicalisation cases have introduced the novel, extensive and multifaceted interaction between two previously entirely separate spheres of law, family law and counter-terrorism law. So the question really is, why have family law and counter-terrorism interacted in the UK in recent years? And more importantly, what are the implications of this interaction from a human rights perspective? Looking first at this why question, I think, and in my work I claim as well, that the recent involvement of the English family courts in the field of national security is symptomatic of and can be explained by reference to a number of recent developments in counter-terrorism laws, policies and discourses in the UK. But here I just want to kind of focus on one or two of them. Firstly, what I call Britain's Muslim family problem. So I'm sure you're all familiar with the claim that in the West generally, and in the UK in particular, since 9/11, there's been kind of a Muslim problem expressed in kind of a growing uneasiness about the alleged cultural descent of the West's Muslims and their segregation from the liberal values of mainstream Western or British society. But whilst Britain's Muslim problem has a number of fronts, including things like integration and immigration, unregulated mosques, hate preachers, child sexual grooming, the importance of the private sphere is quite noticeable. There's a focus on the problematic domestic cultural practices of Muslim families, things like honour killings, unregistered marriages, polygamy, forced marriages, arranged marriages, female genital mutilation, and even increasingly in the last few years, male circumcision. So there have been also, as well, accompanying this, discourse, there's been increasing robust and invasive interventions, legal and policy interventions, in Muslim family life to prevent, harmful family practices, such that the Muslim family has become a highly politicized site of contestation, scrutiny, and intervention, and has come in many ways to symbolize Britain's Muslim problem. And so it's not surprising that even terrorism and extremism have also come to be constructed as part of this, wider Muslim family problem. So in recent years, the Muslim family and home in the UK have become increasingly prominent within counter-terrorism discourses. On the one hand, the Muslim family is increasingly depicted as a risky space. Muslim parents and their parenting choices are blamed and held responsible for the radicalisation of young children. On the other hand, the support of the Muslim family, in particular Muslim mothers, is enlisted by the government in its counter-terrorism efforts. So the Muslim family has become problematised, intervened in, and regulated in the name of national security in the UK. And here we find terrorism, which is traditionally regarded as this, politically motivated form of violence, is depoliticised, it's familialised. Terrorism is constructed as a problem for which Muslim families and their forms of care and intimacy and parenting are, as opposed to kind of structural, socio-political factors, are primarily responsible. And the involvement of the family courts in counter-terrorism can be seen as the most recent and probably stark example of the familialisation of terrorism. And as these quotes from some of the radicalisation cases show and suggest, engagement in terrorism is kind of lumped together without much nuance or differentiation with other problematic Muslim domestic practices such as FGM or forced marriages. They're all kind of lumped together and they're seen as this kind of manifestation or manifestations of Britain's Muslim problem. Another important and related development that I think has created kind of the architecture and the infrastructure that allowed for the emergence of the radicalisation cases in the family courts is the increasing focus on children and childhood within counter-terrorism discourses in the UK. So over the last decade, in both counter-terrorism and child protection policy documents and literature, the UK government has identified extremism and radicalisation as risks that can potentially harm children and undermine their welfare. And the government began to increasingly call on local authorities, schools, even nurseries, and medical professionals to incorporate preventing extremism and radicalisation into their usual kind of child protection and safeguarding duties. And this culminated in the introduction of the statutory prevent duty under Section 26 of the Counter-Terrorism and Security Act in 2015, which basically subjected public bodies such as the children and social services of local authorities, as well as schools and nurseries and hospitals, to the legal duty of preventing terrorism. So again, rather than seeing terrorism as a kind of a method of political violence strategically deployed for the advancement of political ends, terrorism is kind of redefined and recast as a childhood risk. As a kind of a safeguarding vulnerability, resulting in the construction of children for the first time as subjects of the counter-terrorist endeavour, as kind of targets of the national security state. And as a result, what's happened is that this has basically aligned the child protection and child welfare duties and policies and laws of the state with its national security and counter-terrorism aims and objectives, such that protecting children from harm and safeguarding their welfare have become counter-terrorism policy priorities. And on the other hand as well, preventing and countering terrorism and extremism have become child protection and child welfare policy priorities. And the impact of this reconstruction of terrorism, essentially, and realignment on the involvement of the family courts in counter-terrorism is reflected in these kind of quotes from some of the radicalisation cases, where the judges identify extremism and radicalisation as new facets of child protection, as new harms that can justify compulsory state intervention in family life. So finally, let's just look at some of the kind of worrying implications from a human rights perspective when it comes to the involvement of the English family court in the counter-terrorist endeavour. So firstly, radicalisation and extremism are highly politicised and disputed terms that come from national security policy. They're entirely alien to the usual workings of family law, and they also lack legal precision. Yet they're increasingly being used to assess parenting capacity, to assess the suitability of home life and the appropriateness of certain family relationships, and also to limit the rights of parents to bring up and educate their children according to their own religious beliefs. And although, as you can see from this quote here, some of the family judges deciding these cases try really hard to distinguish between the legitimate religious instruction of children on the one hand and harmful radicalisation and indoctrination on the other, often in reality this is quite a difficult line to draw. As this quote from one prominent radicalisation case shows, at times we find that the family judges treat particularly strong religious observance as a precursor to potential extremism and radicalisation. And in other cases, the reverse is suggested. So in one case, the judge says that, this father in front of me here can't be considered an extremist because he doesn't fast during Ramadan. In another case, the judge says that this mother could not have been an extremist because she didn't wear the hijab, she didn't pray on a daily basis. And so that kind of makes us wonder, what's the implication here? Had the father in that case been fasting, had the mother in the other case prayed regularly, and had she worn a hijab, would they have potentially seen them as a potential extremist? Who knows? So there's a potential here within these radicalisation cases for discrimination on religious grounds and religious policing. And it hints at another problem as well, which is a potential kind of double standard. Because it's important to note that currently in the UK, particularly with the publicly available radicalisation cases, they all exclusively deal with Muslim families and allegations of Islamist radicalisation and extremism. Far-right extremism and radicalisation don't really feature in these cases. And finally, family law orders are notorious for being draconian. And this is reflected in some of the outcomes in the radicalisation cases as well. So in some of the cases, children have been permanently removed. In other cases, the local authority has been given significant access to the children in the family home. In yet other cases, the parents have been electronically tagged. In some cases, parental responsibility has been moved from the parents and transferred to the High Court. And so, essentially, what's happened with the radicalisation cases and the involvement of family law in counter-terrorism is that the power and reach of the counter-terrorist state has been really significantly expanded, and it's allowed it to kind of establish the home as this new frontier in the state's ever-expanding war against terror. That's it from me. I'm aware that I might have overstepped my time a little bit, so I'm sorry about that. But that's all I wanted to say, and I'm very happy to take any questions later on. Thank you.
Thank you so much, Professor Ahdash. And we'll do a quick switch in order, and Professor Huckerby is going to speak next.
Oh, thank you. It really is a genuine privilege to be part of this panel looking at these issues. What I thought would be helpful is to sort of do three things. Overview the reasons why the family as a site of regulation, as mobilization, and its impact has not been addressed in analysing national security. Then turn to look at the work the clinic has done in documenting impacts in the Netherlands to really sort of concretize some of these different forms of impact and their interconnection. And then finally to pick up exactly where Dr. Ahdash was taking us to really centre these impacts in a human rights framework to make clear that they're a legal outcome of governmental national security policy making. So, just to note, exactly as Professor Ahdash mentioned, the family implications from national security policies have really been off the radar of policymakers and the human rights community alike for a variety of reasons. One is exactly as Dr. Ahdash highlighted, many of these national security programs touch on areas where there has been routinely characterised by a need for confidentiality. So, for example, child custody decision making, right? Healthcare professional interventions in families. These are areas that are not amenable traditionally to scrutiny for often good reasons. A second reason why it's been really, really tricky to be working in the space of fact-finding on human rights, national security and families has been that many interventions occur at the hyper-local level, centering actors who are traditionally not our national security stakeholders. So for example, social workers who are called to spot signs of extremism in kids, right? It's really has decentered and like localized a lot of decision making in ways that are opaque and removed from our traditional forms of scrutiny of the counter-terrorism machinery of the state. A third reason why it's been really, really tricky to get any meaningful documentation of impacts on families is the policies, and exactly as Dr. Ahdash framed it, they're not just about impact, they're about regulation. And it's constituting significant incursions into the privacy and intimacy of family life, which generates a particular stigma, discrimination, and fear, which can make it difficult to engage in this space to fully document the impacts that are felt by family and family members. Two more quick reasons about why it's been tricky to fully identify and understand the impacts of national security policies in these spaces. There's a significant siloing of expertise, and so you end up having family law judges, for example, pronouncing on the meanings of what is extremism and what constitutes radicalisation. You have social workers, sort of being given like checklists of what to look for in kids in schools, and so this really has been difficult to even sort of access a common conversation with these stakeholders because they're not operating in the terminology and the areas in which we would normally work in this space. And finally, and something that the research rapporteur has really been central in correcting and will take us through directly, there has been a genuine failure to undertake a meaningful human rights and gender-based analyses of the impacts of national security measures. Governments, and we can talk more about this in the Q&A potentially, governments have gotten on board with doing a very thin version of gender analysis of national security, but when you come to really pushing them to really think through, how does gender intersect with the freedom of religion? How does gender intersect with the right to privacy? That is really tricky and difficult to push governments to look at in this space. So that's the reason for the huge, in many ways, apart from Dr. Ahdash and a few other reports, we really have had this extraordinary gap when it comes to understanding the extraordinary impact on families, and that gap is not commensurate with the real impacts that are felt in these spaces. So what are those impacts? So the clinic undertook a range of fact-finding interviews and other engagements with stakeholders in the Netherlands over a significant period of time to really try and understand what these impacts were. I won't go through all of them, but I want to highlight three sort of common themes and then give a couple of examples of the impacts that we saw. So three common themes. The first of which is that impacts are interlinked, and let me give you an example of that. Professor Ahdash took us through some of the decision-making that occurs in the family law space around child protection, so whether that be removals, whether that be supervision, etc. What we found in our research in the Netherlands is that child protection regime was closely connected to what was happening to the family in the criminal justice system. So for example, when you had extremely onerous conditions of detention in the terrorism wards in the Netherlands, it's TAs, like terrorism, it's a dedicated ward for terrorism suspects and those who are being convicted. What we often saw was, as a result of those onerous detention conditions, parents would not want to see their kids under that condition, or they would have highly circumscribed engagement with their kids, and that would have an adverse impact on the child custody determinations, which would be looking at closeness of bonds between parents. And it would take a long time as well. So this criminal justice interaction with the child protection regime is really key. Okay, apparently I'm not being heard by anyone, apart from this wonderful group in the room. Am I being heard on live stream?
I don't think so.
But you're being heard on live stream.
That I'm actually not. Fionnuala and Fatima, are you able to hear me right now? No. Okay. Dr. Ahdash? Dr. Ahdash, can you hear anything?
Just 1 second. I'd like to try this.
You just need to unmute yourself in the Zoom.
Is that what's going on? There you go. That's that easy.
Okay.
Okay.
Thank you.
All right. I've said many, many things. That, yeah, I will not try and recap. But let's keep going. Yeah. Okay, thank you. Okay. So the second sort of overarching feature, and this is reflecting again Dr. Ahdash's point here, is it was really striking to look at the Netherlands policies to see how much families were perceived and treated sometimes as government allies, sometimes as government threats, and sometimes simultaneously both. And that created a whole bunch of policy incoherences that really generated particular impacts on the family. The third feature across these different impacts is that often highly problematic governmental policies in the realm of national security generated further adverse impacts of families. And to give one example of that, which Professor Ní Aoláin may speak to, the Netherlands government has a comprehensive policy of non-repatriation of those, including women and children, who had travelled to Iraq and Syria for reasons linked to ISIS. And that policy of non-repatriation had extremely detrimental impacts on family, and including children in those families, but it also created further adverse impacts. So, for example, it meant that grandparents who were sending money to their children and grandchildren in Syria were being prosecuted pursuant to counter-terrorism financing rules for sending that money in violation of the Dutch domestic law. So we had a sort of, I wouldn't call it a boomerang effect, but sort of a cacophony of effects within these range of national security policies. So a couple of the impacts that we saw, we document the impact of preventive policies. Again, so these are involving sort of upstream engagement of governments that Professor Ahdash mentioned in the context of PREVENT in the UK is a very similar program in the Netherlands of deploying social workers, healthcare professionals, teachers to be the sort of the front lines of the security state and identifying radicalisation, particularly in kids. And just to note on that, it was really important for us to really think about the extraordinary contradictions that emerge when you have a country like the Netherlands with a highly robust welfare infrastructure, actually enabling greater opportunities for incursion into the families under the rubric of national security, like in this way. I'm not going to go, again, we're mindful of the time, but just a couple of other impacts that we saw. The criminalisation detention regime I mentioned very briefly. The administrative and surveillance measures, Professor Ahdash mentioned control orders in the UK. We also saw those control orders having huge impacts on families in the Netherlands. But also, for example, the government policy of cancellation of welfare benefits of those sanctioned individuals who had travelled to Iraq and Syria. That had flow-on effects for family members left in the Netherlands who relied upon those benefits. We also draw attention to in the report exactly the focus on jihadism makes it very clear that in the Dutch context, as Professor Ahdash framed, there is the Muslim family problem that is being addressed through these security policies. And that's really important from a human rights perspective when we undertake a discrimination analysis. To recall that human rights law prohibits discrimination both within and between families. And so that was a really significant part of documentation in this space too. I don't want to go through everything, but I would mention we also highlight child protection measures in the report. We also highlight ways in which, just to echo the language of regulating and also targeting of families, there are a whole bunch of Dutch policies where the government sought to provide individual and group level support to families, again, particularly in the case of either spotting radicalisation in children or what to do if you had a family member who was in Syria. And those particular programs really relied on a whole bunch of gendered and racialised and other stereotypes around familial relationships. They also generated extraordinary resentment, lack of transparency, fear within family members who were seeking support of the government, but also often simultaneously felt targeted by it. The only other impact that I'll mention, and then perhaps I can reflect on the human rights framework after, given our timing. We spent a lot of time trying to figure out the ways in which rules around citizenship and marriage played out in the national security context. Particularly, we were concerned about, for example, proof of parentage of kids who were born in Syria in a context where the Dutch government was not recognising ISIS-issued documents, if those even were existing. And to think through again, like what the cycle of impact was there. And I'll just give endless examples. I think it does really amplify the interconnected nature of these measures. The situation where the Dutch government has refused to actively repatriate those in Iraq and Syria, but it said essentially if you get to the embassy in Ankara, in Turkey, you would be provided with assistance. Right? So to be able to do that requires paying a smuggler, and that requires funding, which would then put families in a position of sending funding to enable that movement into Turkey. What also became really clear is that the government would not accept that children that also presented at the embassy with often a mother, were the child of that mother, and they required certain DNA testing to have that happen. Again, not funded by the Dutch government. Again, it's funding question of relying on grandparents to send money from the Dutch government, which then puts them under the purview of counter-terrorism financing laws in ways that they would then fall afoul. Having to then prove that kids were Dutch citizens, and then potentially being returned to the Netherlands, where the mother would be automatically put in the TA, in the terrorism ward. That was the automatic outcome for anyone who came back from Syria. And then to go through the whole gamut of child protection measures and assessment that look very similar to what Professor Ahdash outlined as well. And so to get an idea of that sort of the circle and interconnectivity of impacts that we're talking about here, with huge implications for the rights to family life, equality, non-discrimination, best interests of the child, freedom of religion, and many, many more as well. And I look forward to talking through those as we go through.
Thank you, Professor Huckerby. And finally, we'll close with Professor Ní Aoláin. Thank you.
Hi, everyone, and apologies for running late to join you. The mandate is on a working level visit in DC this week, and so we were caught in traffic getting to on time, but really, really glad to join this conversation. And maybe I just want to start by acknowledging, in the context of this discussion and thinking about the moment we're in for women's rights in the context of global counterterrorism, that it's been a really long and difficult couple of weeks for women's rights, for the women, peace and security agenda. If, for example, if we can say that such an agenda can be said to exist anymore outside of the words that make up the phrase, and for human rights and for counterterrorism. Particularly as we hit the 20th anniversary of the events of 9/11, as well as the overtaking, the military takeover of Afghanistan by the Taliban. And so a lot of those anniversaries and that sort of changing landscape really brings to the fore some of the costs of counterterrorism more generally, but specifically for women and girls in the contemporary moment. And I think one of the things that my remarks really want to stress is the extent to which the global counterterrorism architecture has grown and expanded over the past 2 decades, but also that counterterrorism has continued to, it's a little bit like a Pac-Man. It keeps eating everything up around it. And that the expansion of counterterrorism and countering violent extremism policy and practice into the lives of women, girls, and the family in particular is one aspect of the ways in which counterterrorism is simply eating up everything around it. My report to the Human Rights Council last spring, which drew substantially on support from Duke's Human Rights Clinic, and for which I'm extraordinarily grateful to Jayne and Aya for, really tried to elevate the ways in which gendering counterterrorism involves addressing the harm of counterterrorism in spaces which women and girls appear, but also where the family is increasingly the target of counterterrorism. And I was also really pleased in that report to be able to build on some of the extraordinary work by Professor Ahdash in her groundbreaking study around the experience of British families, and in particular, and their interface with the CT space. So maybe just to say a couple of remarks to frame what we see happening, where the effects on families are most to be seen. In my report, the Council really tries to benchmark a number of areas where counterterrorism is specifically implicating the lives and the rights of women, girls, and families. And I want to just speak to a few of those by way of illustration. So the first is the focus on sanctions and listing. So as many of you will be aware, post 9/11, through the UN Security Council architecture, UN Security Council Resolution 1267, which predates 9/11, but 1988, which followed some years later, has used the mechanisms of sanctions and listing as a way of addressing or regulating the threat or stated threat of global counterterrorism. And one of the consequences of listing is that, of course, by and large, there are only 4 women who've been listed formally under those global counterterrorism sanctions regimes. But in fact, the focus is primarily men, who are most often seen as the visible target of sanctions. But in reality, those men are often attached to women and families. And the consequence of sanctions and listing doesn't only fall on the, more often than not, man who is the object of the exercise, but all of those around him who depend on him or who are in relationship with him. That regime of sanctions has been heavily criticized by my 2 predecessors, and my report to the Council really also tried to illustrate and amplify the profound due process irregularities that go with sanctions and listing procedures. Those sanctions and listing procedures are so human rights deficient that in fact the current Ombudsman has stepped down in protest at the failure of the Council and states to remedy these profound due process limitations that are found in the sanctions regime. But the broader point that the report made is that when you sanction and list individuals in processes that are opaque, what has been described by one scholar as the form of civil death for individuals, you also, in fact, imply the same consequences for those around him. The structure of sanctions is such that the basis upon which a person is sanctioned is transparent and opaque. The capacity to challenge your listing is extremely limited, and only those who are listed on the 1267 regime, in fact, have an ombudsman to use as a point of challenge. Most people who are listed have no formal means to challenge their inclusion on a list, and neither do their families. And the chances of getting off those lists once you're on them are very, very limited. There are no good off-ramps from being on these lists. And what these lists do once you're sanctioned is they freeze your assets, they limit your capacity to alienate property or funds, and they prevent you from traveling. And again, the costs of that are multiple and varied for families. There is a mechanism for humanitarian exemption where individuals can make a case that they should have access to some, for example, funds that have been frozen as family members. But in reality, those are hard to access and are less than meaningful in terms of enabling individuals to alienate property, to live dignified lives when a person to whom they are attached has been put on a list. And the consequence of that, in a way, it seems to me, is a sort of a form of collective punishment for families as a result of a highly opaque legal process that, again, is so human rights light that the implications are there's neither a human rights framework around it, nor can it be challenged in meaningful ways. And the costs we know for families have been substantial. They include poverty, they include lack of access to services, they include limitations on the broader set of social and economic rights, but also the rights for individuals to participate in societies in meaningful ways, entirely restricted by the implications of these sanctions regimes. So that's one big area. The report also looks at an area that Professor Huckerby has done an enormous amount of work on, which is the countering terrorism financing area, where again we see an extraordinary density of national legislation drawing down from international standards, and in particular the increasingly central role of the FATF, the Financial Action Task Force. And again, this is an example where the targets, although not exclusively men, are predominantly men, but the consequences of the targeting measures affect women, girls, and families in really profound ways. Again, entrenching patterns of financial exclusion for women and families, entrenching patterns of dependency for women and girls and families, and excluding families and women and girls from access to the full panoply of social economic rights by virtue of cutting off their access to funds. And there's a really odd way, I'm struck by the oddity of the ways in which this sort of idea, the International Women's Rights Framework has worked for decades to sort of essentially give women the autonomy to be seen as separate from men, that we value this idea of a woman's independence and autonomy under international law. But one of the kind of reverse orderings that we've seen counterterrorism do is situate women as associated with men. And it's that association with men who are terrorists that essentially are deemed to be terrorists or suspected to be terrorists, or the language of terrorism used around them, then reinscribes women as creatures whose rights are dependent on the men to whom they are attached. And I think that reversal, which is being engineered through a variety of counterterrorism practices, is one that we also ought to be very careful of. The other thing I would stress today in particular is that we've seen the countering terrorism finance mechanisms to be used to target women-led civil society. And perhaps one of the more egregious examples of that happened this past weekend, when the Israeli government defined 6 leading Palestinian organizations, including Women's Committee in Palestine, organizations that I know personally, organizations that have worked to protect women from domestic violence, from violence in society, and have been the strongest voices for advancing women's rights in the occupied Palestinian territories. 6 of those organizations, including Children's Rights Organization and the Women's Committees, were all deemed terrorist organizations by Israeli legislation or designation by minister in the government. And that is illustrative of a pattern that we've seen in multiple situations where these measures, these terrorism measures, are essentially used to choke and stifle civil society, but also women-led civil society in ways that are profoundly problematic. Let me close simply by also saying that I think one of the things the mandate has seen, and I think this is both noted in Jayne and Fatima's comments, is the sort of ways in which aspects of the administrative state have become increasingly colonized by counterterrorism. Family law is certainly one of those areas. Social work is one of those areas. Education, for example, through the PREVENT strategy as an example in the UK, is one of those areas. Health, where doctors and health providers become the sort of nodal points of information for the intelligence and counterterrorism state. And all of these ways in which counterterrorism spreads its tentacles through these sort of structural areas of both provision and institutions in states have had enormously negative effects on families and the rights of women and girls. So I'm really glad to close off this conversation by thanking Duke and the clinic for opening up this conversation and bringing much more attention to the insidious creep of counterterrorism in so many places in people's lives, none of which I think advances either our broader security or even the protection of rights for women, girls, and families. Thanks so much.
Thank you so much, Professor Ní Aoláin. I know that we're just about at time, but we do want to leave a little bit of time for questions. So if we can take maybe 2 questions from the audience and ask them sequentially. Please start us off.
Listening to this talk really brought to mind the recent interview done by the ex-wife of the Pulse shooter, who was, of course, charged and later acquitted as an accessory in his shooting, and has since alleged that he was horrifically abusive to her, even threatening to kill her, and that she couldn't report the possibility of his terrorist activity because of fear that he might kill her. I have to wonder if these systems are just further locking women into these kinds of abusive relationships because they fear recrimination from a system that is also just looking for opportunities to find Muslim people generally as accessories to terrorism, as she was accused of being.
Thank you. And a second question? Joe?
I had a question, or if y'all could talk a little bit more about how a lot of governments are reframing counterterrorism as child protection and using the language of human rights, perhaps saying this is in the best interest of the children, and how to counter that when in fact there might actually be violations of children's rights, whether it's discrimination or infringement into their family lives, and if you could just talk a little bit more about that.
Thank you. Dr. Ahdash or Dr. Aoláin, would you like to start on either one of those questions?
I don't mind going ahead. So the question about the wife of the Pulse shooters is a really good one. I think I've done some separate research, separate to my kind of academic studies, on the impact of prevent funding on Muslim women's organisations and particularly domestic violence ones. And if impact has been catastrophic, it's exactly what you've said. So a lot of, because funding for women's rights organisations has been really, really squeezed in the UK, many of them have had to kind of reframe themselves as counter-extremism organisations. So we promote women's rights because and in doing so we then counter-extremism. So this hijacking of women's rights language by Prevent and the state has led many kind of grassroots organisations kind of force them to almost reframe themselves, and as a result, they've really closed themselves off from the wider community. So there's kind of anecdotal evidence, and there's work being done on kind of collecting this evidence on the negative impact that this proliferation of counterterrorism and its hijacking of women's rights rhetoric on domestic violence victims. So it's a very valid point that you're making. And the other question about reframing sort of counterterrorism as child protection and its kind of tension with child rights, that's exactly what I'm very interested in. And counterterrorism tends to have this a tendency to hijacking, so whether that's the language of human rights or whether that's the language of child protection, and then kind of defeating the very purpose that it seeks allegedly to kind of reinforce. So yeah, I mean, two very interesting and very huge points. So yeah, thank you.
Thank you.
No, I would briefly just comment on this sort of broader challenge of protecting women's rights in places which are CT-led, and I'll use an old example, which is from Belfast, Northern Ireland, where I'm from, not a new example. But it was very clear in the studies that have been done on domestic violence practice and the institutional responses of the state to that through the conflict, that if you were a woman experiencing domestic violence in a nationalist community and you called a hotline, well, what you would get at your door was likely a policeman with an army brigade. So a woman making a call about a need for intervention was then inviting the security state into her home to regulate her husband and her community. And the result, of course, was that women did not use, women in certain communities who understood what the negative impact of bringing in the power, the coercive power of the state and the military and intelligence community into her home would be, was in an absolutely unwinnable situation of both not having an effective remedy, or if she chose that remedy, she was effectively consigning her community and her home to a different part of this, not the protective part of the state, but the kind of the militaristic and interventionist and security-led part of the state, which of course meant that we had decades where women who experienced intimate partner violence were underserved by the reality that they understood precisely what the cost of bringing the state in was. I think we've seen the repetition of those patterns, negative patterns, through the post 9/11. But also with a far more and greater intrusive capacity of the state to survey, to collect data, what we might call the datafication of terrorism, and the implications for that on the hard-won gains of protecting women, regardless of her ethnic, religious, or familial status. And I think this is really what we see as the kind of undermining of broader frameworks of protection. I will also say that my deep concern remains that we are seeing a whole frontal assault on the rights of the child through counter-terrorism frameworks. And we certainly see that in the commodification of children from certain communities as informants, or the kind of the discourse around those children as being non-child. And actually, one of the places where this is most egregiously felt is in the failure of states to bring back their nationals, children and women, from Al-Hol, Raj, Northeast Syria camps, where children, by virtue of their definition of association or birth to a particular parent who has alleged ties to a non-state armed group, are being deemed non-children for the purposes of protection under international law. And again, many of the states who are engaged in these practices of undermining the rights of the child by refusing to protect their most vulnerable children, who are also victims of terrorism, are doing this. These are the same states who tell us that they're defenders of the women, peace and security agenda, that they're the defenders of the children in armed conflict agenda, that they're defenders of the rights of the child anywhere else, but in the context where a child or its parents are deemed associated with terrorism, which happens to be large swaths of the world in which conflicts are taking place today. So I think we have an assault on some of our most fundamental human rights treaties and precepts because of the misuse of CT on a global scale.
And I would just, and by echoing that last point about this extraordinary disconnect between, on the one hand, arguments that national security strategies advance gender and human rights protections, but on the other, exactly that national security policies actually in practice both perpetuate and create new gender inequality within families. And so just to note one example of that we saw in the Netherlands was that we tracked is that the Netherlands' partial ban on face covering clothing, which had been instituted as a national security measure, really created a whole host of gender inequalities in the home that had been present. And so this constant tension that we face in this space of resisting the incursions. There are, for example, and to echo Dr. Ahdash's point, there are a number of feminist and human rights advocates who would push, for example, to have domestic violence interventions be a national security measure, right? But thinking through exactly, using the Lebanon example, the other examples from the UK and elsewhere, like, what does that do in terms of on the ground, both perpetuating and creating new forms of inequalities within families? And so mediating that tension between recognising that governments use gender and human rights as a tool to regulate the families, but actually in practice that these national security measures have adverse impacts is, I think, the ongoing challenge in this space. It really comes to a head when we focus on the family as the location for regulation, mobilisation and impact.
Well, thank you again all for joining us, and a huge thank you to Dr. Ahdash, Professor Ní Aoláin, and Professor Huckerby for speaking on the panel today.
Thank you.